votes.
Motion is approved. All ayes.
Thank you. And now we'll go to item A on our agenda. For those of you who'd like to follow along with the agendas, they are located in the back. Item A was continued from this morning's session. This is an item regarding cannabis land use in Kern County. We had a robust discussion between staff members and the public. I think we had 41 members of the public that made comment on this item. And so now the public hearing has been closed on this item. I will turn to Ms. Oviatt, our Director of Planning and Natural Resources, to make any comments in response to anything that you heard this morning from county department heads or members of the public. And then we'll go to the board after the conclusion of your comments. So Ms. Oviatt, please proceed.
Thank you, Chairman Scribner, members of the board, good afternoon. First, there was a comment from the public that 5 million square feet was analyzed in the environmental impact report. That is not accurate. The maximum amount of square footage for indoor cultivation that was analyzed in the EIR is 2 million square feet. Second, I would like to talk a little bit, there's been discussion in either a ban or a regulate about the amortization program and the 28 that would have to be amortized. First of all, there will be regulations from the state of California that will be placed on their license. So for example, they would be only eligible for an M license, which is medicinal. They would not be eligible for adult because the ordinance in 2009 that they were established under was a medicinal only. They would be required under a ban to close in a year. There was some testimony that seemed to imply that there was a misunderstanding about this. Under a ban, they would be allowed to operate for a year under a temporary license from the state. If they did not get a license for a variety of reasons, they didn't qualify for a license, perhaps they were owned by someone who had a felony, they didn't have the right bonding, you have to put up bonds and other sorts of things, they would have to close immediately. If they did get a license, they could operate for a year. If they then proved that they needed more time to recoup their investment in their building or their improvements, they could apply for an extension, which your board would hear would go through a hearing process, but at some point they will close under a ban. The regulations, however, would apply to them. If they were selling edibles, they would have to be tested through the extensive regulations through the state of California. And I want to talk a minute about these regulations that will apply either under a ban or a regulate. There have been many concerns brought to your board about what's happened in Colorado in regards to children getting candy and other sorts of things and having to go to the emergency room. Sacramento has learned from Colorado. It's actually been placed in the record at the legislature when they've been debating. The legislature was very clear. Whatever mistakes Colorado and Washington State made, Sacramento should not make in implementing these new regulations. One thing we know in Kern County is that Sacramento knows how to over-regulate. It's what they do well. So in this case, they have put together a series of regulations, some of which were in Prop 64, that even if we ban anything that would by accident that people brought into the county, there could be no cartoons, it could not look like candy, they've been very specific, no gummy bears, no lollipops, nothing that looks like a Mars bar or a Twix bar, any of the other kinds of candies that are now being promulgated, such as chronic candy. They have standardized the child-proof packaging so that any packaging has to be it cannot be opened unless you cut it with a pair of scissors. So they've also standardized the packaging for anything that children could eat. And then in addition to that, they are establishing levels of THC that could be allowed in these edibles, which is one of the things in Colorado that led to these emergency rooms, is there was no mandatory maximum level. So even under a ban, there would still be these restrictions so that if people personally brought these edibles in and they did not meet these requirements, we could then also go to the state and point out that these were illegally being promulgated and they could track down where they were manufactured. And so under the amortization we would have additional restrictions under both a ban and under a regulate that we would be requiring the state regulations to impose. I wanted to address the question of a personal use. We had questions in regards to were we going to put more restrictions on personal use. There are limitations legally on to how far we can go on restricting personal use. We are staying within the letter of the law in regards to our restrictions of reconfirming outdoors. We are reconfirming that you can't use it in places that you can smoke cigarettes. However, we cannot restrict what someone does in their backyard. So if someone is using this in their backyard and that odor goes to your backyard, it is a civil matter that you will have to take up. It is not something that the county can regulate, and it would not be a law enforcement matter. So I wanted to touch on the temporary ban to make sure that there was, since this was a modification that was brought forward in the staff report. The temporary ban would be a ban on any new commercial opening. The 28 would still continue under this amortization, but they would only be allowed to operate for the 7 months until the June 2018 election. At that time, the voters would choose either the ban or the regulate, and your board would direct council as to what would be in that regulation. It could be the one that we have brought forward, or it could be some modification of that, as long as it does not go beyond the limitations in the EIR. So I wanted to touch on that. And then lastly, in your recommendations, there are also a referral under any of these proposals to make a referral to the CAO to bring a business license forward for mobile delivery. The concept behind this is even if you ban, if people want a mobile delivery into Kern, into the unincorporated areas, that the county can put a business license on that, and we could require that those mobile deliverers have a business license. So in consultation with the CAO, we are making this recommendation, and that is in the language of all of these recommendations. And with that, I am prepared to answer any questions as well as to direct you to the correct recommendation based on what direction you wish to go. Thank you.
Thank you, Ms. Ovia. Any other comments from staff of Mr. Nations? Anything from council? Okay, very good. Then I'll return to the board. As soon as I see someone punch in, I'll call on you. Supervisor Perez.
Thank you. Thank you, Chairman. Thank you to all of the people that have come forward today. It is always so helpful to hear personal stories and to the reminder that this community is so remarkably diverse. It is growing and changing, and these hearings are really a great sentiment to who this community is and how passionate we feel about what are incredibly complicated matters. I have learned quite a bit today. I've learned quite a bit over the last couple of years in my capacity as a CSAC officer. I've had the opportunity to listen to national experts. I've had an opportunity to meet with the folks out of the governor's office in Colorado who set forth the regulations. They have been advising CSAC and supervisors all over the state of California as to where we know the data to be in an ever-changing, evolving industry. And they have really been very instrumental in helping us understand the complexities, the opportunities, and of course the remarkable challenges that this industry presents to Kern County. And so it is with great respect that I have a slightly different position than I came in with this morning or believe that I would hear today. I've heard overwhelmingly today that this community, at least as we've heard it today and as we've read in the emails and the calls, is very uncomfortable and not okay, if you will, with dispensaries, adult use dispensaries. That is a message I am hearing loud and clear from this community, from diverse members of this community, from users of medicinal marijuana, I'm hearing that loud and clear, and I respect that immensely. I have also heard today from, as I have around the state, from medicinal marijuana users, folks that are suffering from serious ailments, people here that are literally asking this board for mercy for their condition, for their access to medicine, and for the reality by which they live in. I've heard from a veteran this morning. I know many veterans suffering from PTSD. I have a lot of personal experience with it. And the idea that I would be complicit in denying this population access to medicine that is proven to be helpful is something I just simply cannot do. But I hear you loud and clear on the adult use recreational facilities and adult use in public. I've heard that very loud today, and I appreciate all of your input and your passion and the work that you've done to help this board and this community understand just how serious and personal that issue is. I also have the very complicated reality of the structural deficit that this county is living within. You know, the frustrations of this county, our leading industry, are palpable because of what is happening to our number one industry, the industry that has historically been a third of our general fund, or of discretionary monies, is disappearing. It's leaving right before our eyes, and that is so sad. That is really tragic because so much of my family, my community, has relied upon this industry to, reach their level of stability, their, middle-class existence or working-class stability. And so I'm heavy-hearted about that reality. But I do think that it's changing, and I do not anticipate, based on testimony from our treasurer tax collector, our auditor, folks that are really disconnected from the politics of this particular issue. And I believe them because they're the experts. I believe that this industry is diminishing in its presence in Kern County and what it's able to do for Kern County in terms of monetary investment. And I see those investments taking place in other states around this country. And I believe that's the trend. I sincerely believe that that's the trend. And I wish all those folks the absolute best. With that said, I am very eager to explore a compromise with my colleagues today that addresses very seriously the real and legitimate concerns of recreational use, that gives space and opportunity for the many, many patients and citizens, residents of this community that are suffering with physical, emotional, psychological ailments in which they have found comfort, which they have found treatment, in which they have found hope in the medicinal aspects of this product. And I want to explore that with my colleagues. I'm excited about a new industry in this community. I'm excited about any new industry in this community that could create jobs. I see the number of jobs that are potentially created here. I think about the multiplier effects that are present today and can be explored in an incredible fashion. And I have visited these large grows with CSAC in Northern California, and I have seen the multiplier effects in the billboards and the small businesses. I have been there. I have visited those places in a part of this state that produces a $6 to $8 billion industry. And I am very excited about the prospect of what that means for job creation, the stabilizing of our structural deficit that is still in place and that will only be fixed by new revenue or significant cuts to our county personnel, many of which have been present with us today, this morning, or here now. I take those things very seriously, and they're part of the balancing that I attempt to do when I think of these issues by reason, by facts, while I withhold my own very strong, religious and personal views that are very important to me, but that I realize are not shared by everyone. We have a multiplicity of religious groups and cultures in this community, in my district, of which I get to know more all the time. I respect them immensely, and I don't feel appropriate imposing that on other people. And so I won't do that today. But I do want to explore, Director Oviatt, with my colleagues, the possibility of a compromise. I want to hear from my colleagues. I don't purport to have all the answers, but I will share one thing from my heart that has really motivated what I do today, what I have spent my adult life doing, because I believe in it so strongly. When I was in law school in Northwest Indiana, I spent a year interning in Gary, Indiana. And it is a community which is about halfway between where I went to law school and Chicago. So I passed it all the time. And I decided to spend a year there externing and working with the community members and Indiana Legal Services. And it was so stunning to me. I'm sort of fascinated by it. It's the hometown of Michael Jackson and also our president, Donald Trump. It's an incredible place. It is a place that once had a very thriving steel mill industry with really good jobs, it stabilized that community. And by the time that I had gotten there, that industry was mostly long gone, and it had become one of the most violent, economically depressed cities in America. Historically is usually number 1 or 2 in most violent places in America. And the majority of the time that I was there, I worked with grown men filing for bankruptcy. And I was really stricken by this because in that assistance of these men and their families, I heard a lot about what Gary used to be, about how great it was and how marvelous it was for folks to pass an industry down, skill set to their children, to their families, and how great it was to support that town and its growth. And so to see it in this form that I saw it in law school, excuse me, was really quite tragic. And it has left a really profound impact on me personally, because the folks I worked with were at one time, mortgage holders and very proud people, and predominantly African-American community. It really was a thriving place, and it is not that anymore, nowhere near that. And, however the explanation is or who to blame is for that transition is not for debate today. I think it was probably inevitable to some degree, but certainly it appears to me as though the leadership there, the political movements of that community did not really plan well for the transition away from what was once an incredibly thriving and striving steel mill industry. And so I've never forgotten those families. I've never forgotten those men. And it really informs a lot of what I do today, because it helped me really delve into some of the impacts of major transitions, major economic downgrades in a community. They're very real. It certainly can happen to us here. And so I'm terrified of that possibility. And so I want to explore with my colleagues a compromise that will be meaningful for our coffers, that will listen very seriously to a community that does not want adult use recreational here. I hear you loud and clear, and I respect you. But we have patience, we have economic needs, and we are in transition, and we are at a crossroads. I believe that. All of those things I believe sincerely. And so I want to explore that with my colleagues. I'll just open with those remarks and let this conversation develop in the way that a majority of this board sees fit. But those are my initial thoughts. I am really so grateful to our sheriff, to all of the folks that have come out today and have a strong passion and desire that this community be one that works for everyone, that doesn't go too extreme if avoidable, but certainly incorporates all of the needs of this community and make sure that we're at the table in crafting that policy together. So I respectfully submit those thoughts to my colleagues, and I'm very interested in hearing from them. So thank you.
Thank you, Supervisor Perez. Supervisor Gleason.
Thanks, Chairman. Gary, Indiana. I went to school in South Bend, Indiana, which is neighboring Gary in the 70s, and it was a thriving metropolis. And it was an industrial blue-collar town, and it was a remarkable place.
Indeed, and you're bragging now subtly about going to Notre Dame.
Because they won this weekend.
And I
Do you remember
didn't.
Southern Cal?
And I didn't.
I don't,
I don't know
I'm
the
just
first
saying.
thing about that, such greatness, but yeah, no, I spent a year there.
Right,
And
outstanding.
got to know a lot of families there.
I got a couple questions. Maybe I missed it in the 30 hours plus that I spent reading this EIR, which was enormously and a great work product. Thank you very much. But did you address in their advertising, like commercial, billboards, street signs, any of that stuff?
Supervisor Gleason, through the chair, I do defer to council on my comments, but at this point, we don't regulate content, we regulate the size of signs. The state of California did have a legislative, they were going to bring forward a restriction on billboards. It did not pass out of committee. So we're regulating the size of signs, that they be smaller than most businesses, and that they be discreet. We are, however, banning the folding types of signs that you see on the sidewalks. We're banning any movable signs. We're banning any signs that are in the shape. You know, we can ban those types of things. Those are already banned on our types of businesses. So you can't hang a big marijuana leaf off the front of a retail, just like you can't hang other things that could possibly impede the public. But there are some U.S. Supreme Court decisions recently that say that we can't regulate the content of the signs unless it's an obscenity.
Okay, thanks. My second question was, the lady from Ridgecrest asked a question. Do you remember that question? Because I forgot it.
I did, Chairman Gleason, I'm sorry, I apologize.
That was last year.
Supervisor Gleason. She was asking about personal use.
Yeah.
Were we more restrictive? And so, first of all, I was verifying, yes, we are going to reconfirm all of the restrictions that were in Prop 64 so that it's clear. We are going to be more restrictive in that we are not going to allow the use in lounges. For example, an exclusive lounge that didn't have alcohol we could allow that. We're not going to allow that. It is already banned on public buses. It's banned on trains. It's already banned on inside cars. The one place that we cannot restrict that she brought up was, what if someone's using it in the backyard next door to me and it comes over to my house? We can't restrict that. That would become a civil matter between her and her neighbor.
Thank you. If we, I would like to have just a quick rundown to make sure I understand clearly and the public understands clearly that if this board votes to ban, then medicinal marijuana dispensaries stay in existence for a year, and then they close, correct?
Supervisor, there is a list of dispensaries that were determined to have been opened and in compliance with the 2009 ordinance before our May moratorium. And there are 28 of those countywide. There are significantly more illegal ones.
Right.
Those would have to close immediately.
But the 28,
The 28.
would remain open.
If they can get a license, if they can go through the licensing process at the state, which does require a long list of things. For example, a bond, they have to put up a bond. If they have more than 20 employees, they have to have a labor peace agreement. They cannot have any felony convictions. There are other requirements that they would have to go through.
Okay, and in that year, we would have an opportunity to discuss, make recommendations, and develop ideas to either provide. They still have the people who require medical marijuana still have the right to grow their own. Is that correct?
That's correct. 6 plants for personal use.
Now, in the year, we have between now a decision, if we make the decision to ban, and when we have to close those 28 plus approved dispensaries, we can have conversations and make decisions that will enable medicinal marijuana to make changes to the law so we can accommodate the need, whether it's mobile, bringing trucks in from other places, or deliveries, or whatever, what have you. We have ways of accommodating within that year people who require medical marijuana. Is that correct?
Supervisor Gleason, if I understand your question, during that year, those 28 could get a license from the state to also do mobile deliveries, for example, if they can meet those requirements. And for that year, there would be medicinal products. And if I understand your question, yes, the Planning and Natural Resources Department and County Council could continue bringing an item to your board in regards to any ideas or recommendations you have on to how to change the regulation to continue the industry, if I understand your question.
That's a good answer. Thanks.
Okay.
So if the decision to ban today is made, there's still opportunities for us to accommodate the medical marijuana use for the people in need.
Yes, for that year, and you can always reopen the zoning ordinance and go through this process again.
Thank you. Okay. I think it's important we all understand that the world is changing. And I know we are, and I'm not going to give a lecture about it. We all know that. But we do have to all understand that the horse has left the barn. I mean, the state has legalized marijuana, and the decision before this board is not whether or not you're going to have marijuana in your neighborhoods, because you are. The decision is, do we ban or regulate, or what type of regulation are we going to impose on the retail and the cultivation of marijuana? And that decision was made by Prop 64. I had lunch with Senator Fuller last week, and we were talking at length about Prop 64. And she said the only thing she could win was the ability to push it down to the local jurisdictions so that we can make decisions on how best to enact this legislation and to protect and preserve the integrity, quality of life of our citizens. And she was adamant in her opinion that in Kern County, in her opinion, we needed to ban. So it was interesting having that conversation and understanding the changing climate we're in. I think that, one other question before I give you my opinion, this task force that we talked about in one of the 8 elements of the option A was develop a proactive task force. I would like to not just default to, how did you come up with that idea and that membership of that?
Supervisor Gleason, through the chair, I coordinated with the sheriff, the district attorney, county council, and all of those departments who worked with me, and I asked them, what would you need? And they said, this is the dedicated task force you would need. Some of these would be new staff, new hires, and they would be organized along the lines. I asked the sheriff, who was very gracious to work through with me, what does a task force look like? How is it organized? And that's how we came up with that. And then I asked them all what it would cost.
So if I was to, my vote was to be option A, that would include the creation, the way you articulated that task force. I would like to have, well, let me get there as we get there. This is what I think. I think that in District 1, I've been talking about this with my constituents for months. Every city council person that I talk to and every city in my district has banned it. Ridgecrest, Delano, Shafter, McFarland. Every police chief I've talked to urged ban it. I did not talk specifically with Chief Zimmerman, but I heard third hand that that is his position. I did talk to Chief DeRosia up in Delano, and Sheriff, you didn't mention his name this morning. I was going to say something about it, but he is, my last words with him were also in that direction. Every school administrator, every one of them, said ban it. 53.7% of Kern County voted against Prop 64. Overwhelming support from people of Kern County for Measure G. The Navy. Someone mentioned this morning the Navy has zero tolerance. That person is correct. The Navy has zero tolerance for drugs, period. Marijuana, zero tolerance. You smoke, you're caught, you're out. They do random urinalysis every month. So from a Navy perspective, having a county and a city that is co-joined in their effort to curb or to minimize the impact of this Prop 64 is in their best interests. The statistics from Colorado, we heard a lot of them today. We heard about 8% homelessness increase in 2014, 13% in 2016. Criminal activities up. Traffic deaths up 48%. ER visits up 49%. Homicide up 14.7%. Theft and low-level crimes up. Crime rate has risen significantly. Crime rate in Denver is up 44%. Illegal marijuana possession is up, I don't know what, I can't read my writing. Public consumption is up 300%. The statistics are overwhelming that there's issues with the way those states have instituted this law. I don't want to repeat those mistakes. I don't want to have those problems. We heard from staff. I thought that Sheriff did a great job. I thought that the DA's office did a great job. I thought Dr. Walker, thank you, sir, for your inputs. Craig Pope, thank you for your comments. I think the costs associated with any revenues that would be developed are going to be staggering. I don't believe in the final analysis for me, for Mick Gleason, this is not a financial decision. I'm not predicating my decision. I recognize the comments that people have made. I understand that it's going to be, we will be losing the opportunity to make some funds, but it's not, in the long run, the decision that we want to swing this county on. We want to swing this county on our values and who we are and what we are, not by how much money we can make. So I understand the importance of finances. I'm not talking them down, but that's not the tall pole in the tent for me. The tall pole in the tent is public safety and public health. I am willing to compromise, Supervisor Perez, with anything as long as it has the word ban in it. I'm done.
Thank you, Supervisor. Supervisor Maggard.
Thank you, Mr. Chairman. Ms. Oviatt, can you explain to me the two amortization periods to amortize the costs out for the 28 dispensaries that exist? You suggested to us that we should adopt, if we were to take option A, that we should provide a 12-month amortization period for those existing shops. And if we were to regulate, that we might provide a 24-month amortization period. How did you arrive at 12 months?
Supervisor Maggard, that was a recommendation in consultation with council that a one-year time span seemed appropriate for them to get a license from the state. That's part of the issue here. We don't know how long it will take them to get. And second, that seemed reasonable for them to recoup their profit, recoup their cost.
Thank you. Mr. Nations? If you recommended 12 months to her, how did you come up with 12 months? Why was it not 8 months? Why was it not 14 months? Why was it not 3 months?
That was based on a review of multiple ordinances from around the country on amortization periods involving various types of non-conforming uses. 12 months is really the minimum period that we see. It seemed appropriate here because of the fact that most dispensaries have a one-year lease at most. That they don't have anything beyond that. So a one-year period seemed the appropriate fit.
So how did you get 2 years if they are, if we initiate the regulate ordinance instead, and you're going to give them 24 months?
Yes, the reason for that is that we assumed it would take approximately 2 years to get a CUP as well as a permit from the state. And since they were going to continue in business, they had to have the opportunity to secure those permits before they were forced out of business.
Okay, Mr. Nations, if we were to choose option A and ban the dispensaries and the related aspects of the industry, would it not require a permit from the state before a new dispensary could open?
Yes, you have to have you have to have a permit from the state in order to operate. So a new dispensary would not be allowed to open without a state permit.
And can the state issue that permit to an entity in Kern County if Kern County does not authorize the issuance of that permit?
They cannot, and the plan would be for the dispensaries that are currently in operation that we would issue a letter to the state once they are in conformance with local regulations, that they would be authorized to issue a permit.
Supervisor Gleason asked the question, I'll just ask it directly of you. If we were to decide that we wanted to do something about, for example, medicinal marijuana, can we not make that decision the next day, the next week, the next year? We can take up that question and provide something for the medicinal distribution of marijuana if we chose to do so at any time after that we chose to do so, could we not?
You could.
The issue of, it has been suggested even here today by an attorney that is being paid by the marijuana industry, that if we were to choose to ban dispensaries, pot shops in Kern County, that, excuse me, that the industry would gather the signatures, put an initiative on the ballot, and let the people of Kern County decide whether or not they wanted to regulate. Okay, that's irrefutable. That's what was said to us today. Do we not have the option in that event that if the industry were to put up their own initiative before the people, do we as the county have the option of putting up our own initiative on a ballot that would be on this ballot at the same time that would conform to what we, the Board of Supervisors, elected by the people of Kern County, believe would be an option independent of what the marijuana industry might want?
Yes, you do.
We can do that. Yeah,
Yes.
Thank you. Prop 64 provides two things. It provides many things, but two things that I think are significant in our discussion today. One is it provides the opportunity for counties and cities to say no, to ban the dispensaries. I asked our county council to do a survey of all the counties in California and tell us, and a week ago he conducted that survey and told us that as of this point, there are 58 counties in California. 29 of those counties have already decided to ban dispensaries. And there's an array of options about cultivation and growing and whatnot, and the industrial processing of it. But to boil it down to a simple set of numbers, 29 of the 58 counties have already decided to ban dispensaries. 10 of the 58 counties have already decided to regulate dispensaries. That leaves 19 still at issue, one of which is us. It isn't like we're the only place in California that has a conservative set of values. It would be interesting to see where the votes really came from and who voted in California to approve Prop 64, but it's irrefutable that in Kern County we decided not to do that. Another thing that Prop 64 does is it provides, it was said by many people today, it's interesting to me that, and I've been in politics a long time at the local level, and the most common part of a debate is someone tries to speak for you and put you in a box that you have no choice but to agree with this profound statement that they made. And the profound statement that was made over and over again today was, please do not deny us medicinal marijuana. If we chose to ban today, we are not denying people of medicinal marijuana. Medicinal marijuana is still available. Prop 64 provides a provision that allows for, even if there was not a dispensary, it provides for the patient and I think it's 3 people who help assist that person to provide marijuana to them. But the future of this, and this is one of the underlying premises that I have. I think we're in this odd time that we have this false deadline that we have to meet, and everybody thinks we have to make this decision right now. Well, we're going to see over the course of the next several months if if somewhere between 10 and 29 of the counties in California say, go ahead and regulate and have pot shops, wherever you want to have them in your counties, we're going to see how that rolls out. Mr. Nations, does anything prohibit us later if we find out that that is the best idea ever and it's wonderful and there are no problems? Does anything prohibit us from choosing to allow that scenario later rather than today?
No.
No. We can make that decision later. So I don't think it's something we need to rush into. I've thought a lot about the consequences to my district. The vast majority of pot shops in the greater Bakersfield area exist in Oildale. I represent geographically maybe 60% of Oildale, but I represent the 60% of Oildale where these things are all located. Most of them are located. And I represent much of East Bakersfield where many, many pot shops are located. So I've tried to lay this out in a way that makes sense to me, and I hope that it makes sense to you. I know there are some who think that the decision to ban dispensaries is based upon some unenlightened, backward, I'm an old white guy from the 50s, and what do I know about it? There are some people that have said those kind of things. And people have all kinds of opinions about this, even our planning commission, who I have great respect for. I never told my appointee to the planning commission what she should do. I never even had a conversation with her about it. I respect her opinion. But the difference between a planning commissioner and the difference between all the folks in the community that have opinions about this and the 5 of us is I am 100% responsible for the consequences of the decisions I make. And I have to look in the eye the people I represent. And the people who I represent have some very strong feelings about this. Those folks have the luxury of espousing their opinion without being responsible for the consequences. I don't enjoy that luxury. My overriding concern is what the consequences of this action will be if we were to regulate as opposed to ban. My district has felt the disproportionate weight of and the innumerable consequences of those dispensaries already here. Poor neighborhoods and communities are forced by the suggestions that are made to us today. Now, there's been a last-minute attempt to moderate that, to see if that moderation might change our opinions. But bottom line is, the EIR portrays a scenario where the disproportionate weight and innumerable consequences of the dispensaries are going to be forced upon poor neighborhoods. Poor neighborhoods and communities are forced by the suggested scheme to bear an unfair burden and pay a much higher disproportionate price than all the rest of our community, basically. It's easy to extol the supposed benefits of a gamble such as regulating, and I think that's what much of California is about to see, when you don't have to suffer the consequences. The people I represent will directly suffer the consequences. We have, interestingly, not talked very much about the statistics of crime, and I'm not going to take a lot of time to tell you about those statistics, but many of these dispensaries are located in the neighborhoods I represent. In those dispensaries and in their parking lots are murders, multiple murders, kidnappings, torture, sexual assaults, gun battles that rage into the neighborhood, a gang presence and activity, extortion, and countless robberies. Somebody naively said, a cash business is not what attracts robbery. It's the way you run your business. With all due respect to that person, that's ridiculous. Cash is a priority to steal. In addition to the crime, there are scores of stoned out customers for those dispensaries that spend all day out in front of many of those dispensaries. They loiter there. They cause customers for the adjacent businesses to avoid them. There's not a polite way to say this. They urinate on the walls of the adjacent businesses and churches that are in those neighborhoods. They defecate there sometimes. There are sexual acts that take place right in front of the dispensaries. Go 100 feet in another direction up and down, because these people are there all day long. There are armed guards walking in the area where you might go to get your pet food, or you might go to get a coffee or a sandwich. There are armed guards walking back up and down the sidewalk in front of that, where these parents and their children are having to walk in front of it. There are long lines on almost every Friday afternoon as people line up to get their supplies for the weekend. There are 420 celebrations on April 20th. There are 420 celebrations that draw big, huge crowds of people that line up in front of the dispensaries, blocking access to the adjacent businesses, token away without any regard for the women and children, mothers and children, I should say, and elderly, anybody who is there and never intended to be a part of that big party. And then there are other business districts that are already struggling in these blighted neighborhoods. These places are barely holding on. The businesses are just eking out survival, and we need more of them to be successful and to provide more jobs. But because of this industry and wherever it is located now, they're concentrated in the 2nd district now, and the 3rd district, I'm sorry, and every one of the iterations of the maps still concentrate them largely in the 3rd district. They're a magnet to other businesses that come along with them. Those other businesses are hydroponic supply shops, which is a front for how to grow your own. Marijuana doctors that flaunt rules and set up across the street from schools and the kids in my district have to walk in front of. Internet cafes are very often right in the same areas, and massage shops. Why is that? Why does that happen? And why do I have a concern that'll happen wherever we locate these, even if they're in industrial areas? Because the people that are being sold to, some of them are poor patients who have terrible circumstances. Some of them are, I suppose, otherwise law-abiding citizens. You can argue whether or not they're federally law-abiding or not. But bottom line is they're exploiting. It's inescapable. These shops are exploiting, to some extent, a drug culture, and that drug culture is such that it draws these other, what I think are nefarious businesses that are making it harder and harder for these few neighborhoods to be able to survive and pull out. I really have been surprised by part of it, and it's talked about, how much money can we make? Well, to ask me to turn my head to the firsthand consequences I've seen now for years of this industry nesting itself in these neighborhoods, to ask me to turn my head and not worry about that in exchange for money because I might need it for this, that, or the other thing is frankly offensive to me. I represent people. We need money to make it work, but I represent people, and they are suffering because of this. And their children, it isn't fair that their children have to grow up in a neighborhood where this is what becomes normal. Because that's not what's normal at the Rosedale Promenade. That's not what's normal at Hagen Oaks. That's not what's normal at the Marketplace. That's not what's normal at the Tajon Outlets. But it's what's normal in these poor neighborhoods that are stuck with it because there's a convenient way, intentional or not, that's where they're left to go. And I represent the people who are stuck with it. I won't do it. I can't do it. I cannot turn my back on those people. So I'm going to vote today, and I'm going to move today that we adopt option A, which bans these dispensaries. I don't agree with every part of A, but it's what I'm going to motion that we do. And I think we're going to see in a year, if a year is the time that it takes for these amortization periods to work out, we're going to see during that period of time some of the consequences that occur. And if there is another way that we need to provide medicinal marijuana to patients who are suffering, I'm interested in knowing what that other way might be. Some who I respect speculate that the future of marijuana won't be brick and mortar stores, it will be home delivery, and that will be pretty much the way most people will do it. I don't know what that answer is, but I know that today, for the reasons I've given you, I can't turn my back on the neighborhoods I represent, and I'm going to motion that we adopt Measure A, or option A. Thank you.
Thank you, Supervisor. Supervisor Couch?
Thank you, Mr. Chairman. I just have a very few comments to make. The first one is I've been asked repeatedly how I'm going to vote on this issue over the last couple of months. In fact, my staff has almost people have demanded of my staff that they tell them how I'm going to vote. And we have tried to explain to them, and so I want to explain today why we've never said anything about that. There is no faster way to land us in court and to waste your tax money than for me to make a pre-decision about something this important and then to tell everybody how I feel about that. It's important for us to take in all the public input and sit through all the public hearings and hear what everyone has to say and to read all the written documentation before we make a decision. And I'm hopeful that all the people that were demanding to know exactly how I was going to vote can now understand that. I also want to thank, and I want to make sure I say that the comments from our law enforcement community, our sheriff, chiefs of police, and also the directors of public health, director of behavioral health, director of public works, our CEO of Kern Medical, the district attorney, assistant district attorney. I probably left somebody out there, but they all, I respect those people greatly, and their comments were very important to my decision. I believe, and I'm going to second Supervisor Maggard's motion, that the most prudent course of action at this time is to adopt option A, which is a ban. But for all the things that were just articulated by Supervisor Maggard and Supervisor Gleason, we have many other options still in front of us. And by the way, in this case, I'm not going to reiterate this, but as we all know, this ban is not really a complete ban. You're still going to have it in your neighborhoods. I think it's imperative, and I want to know, I would like to make sure that the CAO's office or someone is the person that is accountable for this. We need to monitor, and I would like a report to us on any efforts at either a referendum or of a measure that would be placed on the ballot via a signature gathering drive. Supervisor Maggard mentioned that, but I think at that point we have another decision to make. I don't think we're done with this, frankly. I don't think this is the end. This may, in fact, be the beginning. We'll have another decision to make, and that is whether or not to place a competing measure on the ballot, and whether it's the elements that have been articulated today in option B, or whether it's a derivative of that, or one of the other options that came up. I don't know, but we will need to move quickly, and we'll need to, well, we're going to need to move quickly. I'm also interested in, and maybe this is the only compromise that's available, Supervisor Perez, but that's, I'd be interested in the legitimate medical use and hope that we can address that in the short-term future. Anyway, those are my comments. Thank you, Mr. Chairman.
Thank you, Supervisor Couch. Supervisor Perez.
Thank you. Supervisor Couch, but your second is to the A option, not the temporary ban, but the current option A.
I'm seconding Supervisor Maggard's motion, yes.
Supervisor Maggard, which is the full ban, option A. Okay, thank you. Can I, Director Obiant, could you explain to us what it appears as though this board is moving to a ban? We haven't voted yet, but that's how it appears to me. So what are the next steps? Perhaps Mr. Nations is the right person to ask this question to, but what are the options moving forward? I understand that under a ban, if this board imposes a ban, that there are 30 days to potentially come back with an undone decision. Can somebody lay out for the public what are the next potential steps should this board move towards a ban?
Supervisor Perez, through the chair, could I ask a clarifying question, since I see you over the top, Mr. Nations, as well as confused? Do you want to know what the county is going to do to implement this resolution, or do you want to know what things might happen if we implement?
Both, if you don't mind, just so the public is fully informed of what we should expect to be coming down the pike in the next 30, 60, 90, 120 days, whatever you foresee as possibilities.
So for the implementation of this, we would be implementing the ordinance. We would be taking out of the ordinance and repealing all of the other medical marijuana moratoriums. All of those things would come out of the ordinance, and we would put this new ban statement in. The Planning and Natural Resources Department would coordinate with the Public Works Department to put together a process to reach out to the 28 already determined, continue our deliberations on the others that have not been determined to be legal, to arrange for them to have a inspection of their premises for building purposes. If they refused, then they would be considered out of compliance with this ordinance. If they accepted, they would work their way through their building department compliance list. And when we received that, my department would then issue a letter for them to take to the state of California, indicating that they could apply for a license for a 1-year period of time, a temporary license, and that it could only be for an M class. We would also continue our efforts in discussing with the CAO the implementation of the mitigation measure in regards to this cannabis activity enforcement, and we would be looking to see how to phase that in over the budget season. And we would be then also continuing deliberations on dispensaries that come forward who are making their assertions that they were in place prior to the moratorium. So that would be the implementation that we would do. I defer to Mr. Nations in regards to other actions that could happen.
Thank you, Director. Mr. Nations?
Supervisor Perez, through the chair, there's several things that could happen. Some of them were alluded to by some of the speakers today. One is individuals unhappy with the board's action, assuming it were to adopt option A today, would be to file a referendum petition. They would have 30 days in order to gather sufficient signatures, approximately 10,600 signatures, and present them to the registrar of voters. If that petition, once that petition is filed, the option A ordinance would be stayed. It would not have any legal effect. And the board would then have to decide whether to repeal option A or place it on the ballot for an election not less than 88 days away. Another option would be for proponents unhappy with the decision would be to circulate an initiative petition of their own. That is can be a long process. They have 6 months essentially in order to accomplish that, and then if they gather enough signatures for it, the board must either adopt the ordinance that they have developed or place it on the ballot. If they gather 10% of the signatures, which would be approximately 10,600, the board could place it on the June ballot. If they gather 20%, the board would be required to call a special election or just adopt the proposed ordinance outright. Another option that was alluded to today is a lawsuit, a legal challenge to the board's adoption of option A today. We believe that legal challenge would be based on the county versus TCEF decision. We have analyzed that and think we understand the theory behind that case. I would prefer not to discuss my thoughts on that in public at this time, but that would be I believe the legal challenge that would be brought. And so those three are the most likely things that could happen. Obviously, your board always has the ability to develop, as I indicated earlier, an initiative or an ordinance of its own to be placed on the ballot for consideration by the electorate at any time. Thank you.
Okay, thank you, Mr. Nations. Regarding the ordinance that the county could place on the ballot, would that be in conjunction with let's say there are members of the community who place their own matter on a ballot? Should they be successful in doing that and the county is not happy with that because we didn't draft it, we could put a competing ordinance on. Is that correct?
That's correct.
Okay. And what can the county do to campaign for that ordinance, to spread the word on that ordinance? Do we have a budget in place to inform the public of which one the county supports versus any conglomerate of community members or business interests?
Supervisor Perez, through the chair, the county could not campaign for it. The campaign for that, any ordinance developed by the county would have to be taken up by organizations outside the county. The county is not allowed to participate, to advocate at that point.
Can the county spend any money to inform the public?
No.
Okay, so how will the public know which one the county supports?
Well, through the ballot summary.
Oh, got it. The ballot summary will say the county supports A or B or what?
It was proposed by the Board of Supervisors.
But we can't take any official action from the dais in our official capacity to inform the public of what the county would be promoting.
You could not advocate for it.
Okay,
Correct.
thank you, Mr. Nations, very helpful. I'm done.
Yes, Supervisor Maggard, and then I'm going to Supervisor Gleason.
The last words out of your mouth, Mr. Nations, were, I hope I'm not paraphrasing them, we could not, how did you say it again? The essence of what I took away from it was, I think you just said, you implied that we might not be able to speak about this.
Well, okay. Speaking about it and advocating for it are two different things. And what the ethics rules provide is that once you have a measure on the ballot, county employees and elected officials cannot, in their official roles, advocate for a measure.
So are you telling me that I cannot be interviewed in the news, I cannot be interviewed by a radio show, I cannot be interviewed by the newspaper, I can't do any of those things?
I'm not saying that. You can
I didn't
provide,
think so.
you can provide information, but you cannot advocate.
Well, we'll have another conversation about that. Because last time I remember, we live in America and I get to voice my opinion. So, thank you.
Mr. Nations, just to follow up, is that a distinction from advocating from the dais versus advocating out in the public? Is there a distinction there? And as I think to be continued, that conversation, as Supervisor Maggard suggested, because I think there is a distinction there. But we'll wait for that conversation.
Okay?
Thanks. Supervisor Gleason.
Thank you, Mr. Chairman. My earlier comments about the word ban and any compromise, I wasn't being flippant. I was being serious because I think that's where also you were going, Supervisor Perez, and I think I agree with your concern on satisfying the need for a bona fide system, a legitimate system to provide the capability for people in need to get marijuana as a treatment. And I'm very much interested in seeing if we can find some way to do that and accommodate that need. If I approve option A, if I vote yes on this, does this mean that the task force is now created the way that it has been projected in this, or can that task force be adjusted, the membership? I'm very much interested in knowing how that was developed, what the mission statement is of that task force, how they're to perform, when they're to perform, and I've got a whole bunch of questions about that task force. And what I want to know is, if I vote yes on option A, am I accepting the structure of that task force the way it is designed?
Supervisor Gleason, through the chair, there is no task force formed. I was asked to prepare a mitigation measure for the environmental impact report, and I worked with them and asked them, what would it take to enforce this?
Okay.
Obviously, that new mission statements, new reconstruction of it can be made. However, the issue was what resources are necessary to have proactive ban was the question.
Got it. So we can make adjustments to that task force as we move forward.
Yes,
Correct.
the task force is not part of the ordinance.
Okay, that's what I needed to know. Thank you.
Okay, I don't see any other requests to speak, so I'm going to go ahead and go quickly. I will support the motion, the comments that my colleagues made for their reasoning, I thought were great points. There were a lot of terrific points that were made by members of the audience that spoke, our department heads. So I want to thank staff for all of their participation, all their hard work in getting us to this point. The 41 members of the public that spoke. One of the main things I'd like to tell you is not just showing up and being a part of the process, but thank you for how respectful you were. Everybody, I thought, really conducted themselves admirably, and so just want you to know how much we appreciate that. It really helps the process when everyone does that. I've got a few reasons why I'm supporting that I'd like to highlight. First of all, clearly the voters of Kern County, they voted against Proposition 64. Our cities have all voted for bans for adult use, recreational use, dispensaries, et cetera. Our law enforcement leaders are strongly against it. I think that one reason for that, and Supervisor Maggard touched on a little bit, he was speaking about Oildale, but I have the town of Rosamond that I represent, and when you had a member of the public from Rosamond that said there's one for every 1,000 people in town, that was no exaggeration. That's a town of about 18,000 people, and we've had as many as, I think, 22 there. And it's a situation that's completely ridiculous, and the town has been outraged about how their commercial areas, their historic downtowns, have been taken over, literally taken over by dispensaries. In Mojave, they have one big shopping center with the one grocery store that used to serve all of Cal City and Mojave. You're seeing evictions occur there, so marijuana interests can move in. And one of my seniors said that we're afraid to go to shop there because of what's happened. We found over 1,000 plants in that shopping center a few weeks back. And so those are the kinds of things that are weighing heavy on my mind as we looked at this. Clearly, our community, I believe the majority of our community does not want to see adult use. However, our community, Kern County, a few years back did vote for Measure G, and it provided a little provision for a provision for medical use in certain areas of the county. And I think that the testimony from folks that are showing up that I believe are legitimately ill, I think that we need to be open to a conversation about how to address that. But as has been said, we're going to have time to do that. We have the amortization period, so we're going to have a period of time to figure out what is a solution for that, at least the best one that we might want to come up with. And so I will support the motion. And so we do have a motion and we have a second, so I will call. I'm sorry, Ms. Soviet, you need to make a recommendation for us.
Chairman Scrivener, could I read?
Reflecting, yes, if you turn your mic on, that's going to be better.
It was on.
Thank you.
I apologize.
Yeah, so if you could read a
I could-
recommendation,
yeah.
please, reflecting the motion.
For the record, I'd like to read this into the record and also note that the findings that are recommended are under the tab Option A, Ban Ordinance. Adopt resolutions, recommended findings, and enact ordinances. Certify the environmental impact report. Adopt Section 15091 findings of fact for Option A ban. Section 15093 statements of overriding considerations for Option A ban. Adopt mitigation measure monitoring and reporting program for Option A ban. Repeal Chapter 19.120 medical marijuana dispensaries, Chapter 5.84 medical marijuana cooperatives and collectives, Chapter 5.85 medical marijuana cultivation, Chapter 5.86 moratorium on new medical marijuana dispensaries. Adopt amendments to Title 12 parks, recreation areas, and public places. Adopt amendments to Title 19 Kern County zoning ordinance. Adopt amendment to Chapter 19.09 interpretations and general standards, and Chapter 19.114 enforcement and penalties recommended by staff, and make a referral to staff to amend the lease with the county fair to prohibit cannabis vendors. Make a referral to staff to bring back a requirement for a business license for cannabis mobile delivery into the unincorporated county areas, and adopt suggested findings in the staff report.
Thank you, Ms. Oviatt. And so that is the motion on the floor. Please cast your votes.
The motion is approved, 4 ayes, 1 opposed. Supervisor Perez.
That brings us to the conclusion of our business, and I will entertain a motion for adjournment to Tuesday, November 7th at 9 a.m. I'm sorry. I apologize. We do have a couple of other items, and I almost made it through here without forgetting that, but we do have item number 1 on the agenda, public presentations. This portion of the meeting is reserved for persons to address the board on any matter not on this agenda, but under the jurisdiction of the board. Board members may respond briefly to statements made or questions posed. They may ask a question for clarification, make a referral to staff for factual information, or request staff to report back to the board at a later meeting. Also, the board may take action to direct staff to place a matter of business on a future agenda. And so if there's anyone who would like to make a public presentation, please come forward, state your name, and you have 2 minutes. Okay, I don't see any requests, and I'll move on to board member announcements or reports. No interest there. So now, I will entertain a motion to adjourn to November 7th at 9 a.m. We are adjourned.